when you're ready to
Think we're
start.
good. Go
Okay.
ahead.
All right. Welcome back, everybody. And I've changed my virtual background to, I think this is Walker Glacier, which was a great walk that I had on another Alaska trip. And called Walker Glacier. That's because you can walk on it. It may have been named after some guy named Walker, but it's another lovely place. And I am missing the opportunity to be in Alaska for this symposium. There's, what a terrible thing to have a great opportunity for a symposium in Alaska, but not get to go. So I hope things are going well in Alaska. And I know it's getting to be probably early winter. I remember last time I came out, Deborah O'Regan said, "Be sure to bring your coat. It's going to be cold." And she was right for somebody. I'm originally from Buffalo, but as a North Carolinian now, my blood has thinned a little bit. We're going to have two panels today. The first panel is going to focus, we call it Engaging an Alaskan Democracy, kind of a generic, a little bit of an open texture, but trying to look at a couple of specific issues. And I'm very pleased with our panel members today, the first two of which are also authors for our symposium. Their articles will be published. They're part of the CLE program, but their articles will be published in our upcoming issue, along with some student comments and Professor Chemerinsky's keynote address. So let me introduce our two speakers. We'll spend about 15 minutes presenting sort of a summary, the gist of their articles, and then we'll have a comment. And then actually, we hope to have some significant time for questions and answers and discussions about the topics we address here as we kind of look at the contemporary issues about Alaskan election law. Our first speaker today is Elizabeth, or Libby, Bacalar. She's currently a municipal attorney in Alaska, previously served as the Senior Associate Attorney General in the Department of Law. She's represented a range of public and private clients and civil litigation issues, but a great deal of work on election and ballot measures, and certainly is one of the great experts on her topic, which is dealing with the Alaska Ballot Initiative, both its historical and present day practices. She received a BA from Brown, and then her JD from Brooklyn Law School, and clerked for Superior Court Judge Beverly Winslow Cutler in Palmer, Alaska. Our second speaker today, who's written a couple of different articles for the Alaska Law Review, and I think was involved in some of our previous symposiums, we'd like to welcome back Professor Chad Flanders. He's a professor at the Center of International and Comparative Law at St. Louis University in St. Louis, Missouri. His research interests are a wide range of topics, including election law and constitutional law. So he's right in his wheelhouse talking about this topic. He received his BA from Hillsdale College, and then a master's and PhD from Chicago University, and his JD from Yale Law School. Clerked with Warren Matthews on the Alaska Supreme Court before clerking with Judge Michael McConnell on the 10th Circuit, who was a co-clerk of mine when I was a law clerk. Wonderful judge. And he's going to be speaking with us today about some of the impacts of campaign finance law and whether there is something special about Alaska that may someday be recognized by the Supreme Court. Our commentator today on these topics, and will be sharing some of her own perspectives on sort of constitutional issues relating to election law, is Susan Orlansky, who I have known before she came to Alaska in 1980, as we were both at Harvard Law School and both on the Harvard Law Review together. And she attended my wedding, which was very fun to have her there and think back on those good days. We worked on an issue at the Harvard Law Review on the developments of law. And one of our co-workers was some guy named John Roberts, who maybe some of you have heard of. So we were all classmates together and colleagues there. I'm sure many of you know her incredible record in Alaska, where she's been there serving, first working in the Alaska court system, and then with the Public Defender's Office. She moved to private practice after that and has had incredible sort of work as an appellate attorney, working on many of the important constitutional law cases that they decided. Currently, she's of counsel to Reeves Amadio but continues her work with the ACLU and raising a number of issues in appellate practice. So it's quite a privilege to have Susan Orlansky to serve with us on this panel. She's also a previous author for the Alaska Law Review. So let's just jump right into it. Libby, please help us understand something about the history of the ballot initiatives with an Alaska focus.
Okay, thank you so much. I appreciate being here, and I recognize a lot of folks on this Zoom, and it's nice to see everybody's names. I'm a little intimidated following Dean Chemerinsky, and this is my first law review article since law school. So I haven't, I'm a little bit new to academia, but Cormac convinced me to write this piece, the title of which is Alaska's Ballot Initiative Today, History, Practice, and Process. And what I try to do in the article, successfully, hopefully, is to offer a comprehensive overview of direct democracy in Alaska, that is the ballot initiative, from its constitutional origins to the role of the legislature and all of the technicalities of enactment. This type of comprehensive overview hasn't been done since the early 90s. A lot has changed since then, both in terms of case law and practice. So it seemed like it was time for an update. And that's what the article is. So just an overview, Alaska is one of 21 states that permit some form of direct democracy through the ballot initiative, allowing citizens to propose and enact laws at elections as an alternative to legislative enactments. Since statehood, over 50 initiative measures have been presented to Alaska's voters, with many more that ultimately failed to reach the ballot for various reasons, either certification, litigation, or failure to collect sufficient signatures. Because initiatives often deal with controversial subjects, they're frequently litigated, and the Supreme Court of Alaska has developed a vast body of case law that helps guide election law practitioners and initiative sponsors both. The initiative overall has proven through the decades to be an effective, if somewhat cumbersome and costly, way for Alaskans to enact laws when their elected officials fail to do so through the regular legislative process. I've had conversations with legislators who don't like initiatives, and I always say, well, then enact the laws that your constituents want to see. So the initiative, along with referendum and recall, which my paper doesn't focus on, has its origins in the Alaska Constitution. The delegates, and I think Professor Chemerinsky, Dean Chemerinsky, alluded to this earlier, the delegates believed the ballot initiative was a fundamental right of the people, and they tried to strike a balance between the exercise of that right and the preservation of legislative power by imposing certain restrictions on its use. And those restrictions came down to four main restrictions, all of which are contained in Article 11, Section 7, and evaluated by the Lieutenant Governor, who oversees elections in conjunction with the Department of Law prior to an initiative being certified for the ballot. So first, an initiative can't be used to make or repeal appropriations. Second, the initiative cannot be used to create courts or define rules of court. Third, the initiative cannot be used to enact local or special legislation. And finally, it cannot be used to dedicate revenue. Now, the legislature also cannot dedicate revenue or enact local or special legislation. However, it can, of course, make or repeal appropriations and legislate courts. In other ways, the power to enact laws by initiative is analogous in almost all respects to the legislature's power, and the Supreme Court treats it that way, not as a secondary, option B, but more of a parallel process. Each of the four restrictions I just mentioned have been litigated extensively, some more than others. The most frequently litigated is the appropriations restriction, in part because the Constitution doesn't define appropriations. The court, in dealing with initiatives, has consistently expanded the scope of public assets subject to appropriation beyond just money to land, fish, municipal assets. And in each of these cases, the court focuses on what it deems the two core objectives underlying the appropriations restriction. The first of which is to prevent giveaway programs that would allow the electorate to bestow state assets on itself. And the second is to preserve to the legislature the power to make decisions concerning the allocation of state assets among competing needs. You see a lot of appropriations challenges lately in the natural resources context, because these are since the Pullen case in 1996, natural resources have been deemed, the natural resources of the state have been deemed public assets subject to appropriation, and they're often the subject of ballot measures. So we've litigated that frequently. Local or special legislation, that's evaluated by considering the subject of the initiative and determining whether it's of common interest to the whole state. The benchmark case here was Boucher versus Angstrom, which found that a ballot measure intended to move the state capital was not local or special legislation because it was a matter of statewide common concern, despite not operating evenly on all parts of the state. Subsequent initiative cases in the fisheries context, despite being focused on certain areas like Bristol Bay, make clear that ballot measures do not have to have statewide geographic application, but they do have to have statewide impact. And if they do, they're likely to survive a local or special legislation challenge. The dedicated revenue restriction focuses on its legislative analog in the public finance portions of the Alaska Constitution, which provide that proceeds of state taxes and licenses shall not be dedicated to any special purposes. Again, the court uses the same analysis in both contexts and asks whether the measure creates specific rights to funds for specific groups, earmarks any funds for particular organizations, or creates mandatory expenditures. The City of Fairbanks versus Fairbanks Convention and Visitors Bureau is the leading case on that restriction. And there the court evaluated a bed tax and found it could not be a dedication of revenue because it did not do any of those foregoing things I just mentioned. Creation of courts and rules of court is a more straightforward restriction. It's only been addressed once by the Alaska Supreme Court in the context of an initiative that would have set maximum allowable attorney's fees in personal injury cases. And that's the Citizens for Tort Reform case. The court concluded that that was a rule of court subject to the scope of the people's power to legislate by initiative and therefore invalid and not able to go to the voters. But both the judiciary and the legislature have roles that go beyond these restrictions. And there are 4 important concepts that come into play when sponsoring and evaluating ballot measures. The first is the scope of pre-election review of ballot measures. The second is the source and the meaning of the phrase clearly unconstitutional under controlling authority. The third is the single subject rule. And finally, there's the role of the legislature in the initiative process. The pre-election review standard is broad. It's very favorable to sponsors. The court looks at these 4 restrictions, the Article 11, Section 7 restrictions, before saying an initiative can't go to the ballot. It also looks at whether the law would be clearly unconstitutional under controlling authority, i.e., whether it's so obviously unconstitutional so as to be a waste of state time and resources. And the Supreme Court, Alaska Supreme Court, has used the examples of Brown v. Board, Roe v. Wade, secession from statehood, those kinds of obvious, clearly unconstitutional matters. So pre-election review also considers whether the measure violates the single subject rule, that a bill be confined to a single subject. We saw this recently in the fight over 19 AKBE, the Better Elections measure. The single subject rule is very broad. It's been interpreted broadly. It was just interpreted broadly this year. And the purpose of it is to prevent log rolling. The court has held that all that's necessary is that the act should embrace one general subject and that all matters treated should fall under one general idea and be connected to each other in a logical way or in practical understanding so as to be part of or germane to one general subject. And ballot measure 2, which I think we'll talk about later today, dealt with campaign finance and the top 4 nonpartisan primary and ranked choice voting, all of which were found to be a single subject under elections reform. The scope of pre-election review is critical to understand because it means that neither the executive branch nor the judiciary can simply conjure constitutional arguments that would need to be litigated in an as-applied challenge after the election. So for example, many initiative bills have due process issues, equal protection issues, potential contractual interference, and other possible constitutional problems. But the court's been very clear that these sorts of claims are not addressed before the election because doing so would be hypothetical advisory opinion making and create an insurmountable barrier to laypersons crafting legislation, and also turn the lieutenant governor and municipal clerks at the local level into quasi-judicial bodies improperly adjudicating complicated concepts of constitutional law that go well beyond the articulated scope of Article 11 Section 7 restrictions that are permitted to be examined in the pre-election context. Another critical thing to understand is the role of the legislature, both before and after an election. If an initiative is properly filed, the legislature will have one full session to pass substantially similar legislation and void the initiative. What constitutes substantially similar legislation is really a fact-based inquiry that necessitates comparing two initiative bills, or one initiative bill and one legislative enactment. This recently came up a few years ago in the context of 17 AKGA, the Governmental Accountability Initiative that was voided by the Lieutenant Governor with the advice of the Attorney General's office after the legislature passed substantially similar legislation within the requisite time period. So if and after the ballot measure passes, the legislature can amend it at any time, but may not repeal it within 2 years. And whether an amendment actually functions as a repeal is is a fact-based question in which the court focuses on the extent to which any amendments, quote unquote, vitiate the intent of the initiative. So there's a limit to what what the legislature can do on amendment before it starts to cross over that line into a repeal. So segueing from the academic to the more practical, how does the initiative actually get onto the ballot? It comes down to strict compliance with a pretty rote statutory process and signature gathering effort. And it's useful to think of that process in 3 distinct phases. One is the application and certification phase. 2 is the filing, petition, and signature gathering phase. And the 3rd is election and enactment. During the application phase, initiative sponsors file a packet with the Lieutenant Governor that includes 100 qualified voters, the proposed initiative bill, of course, and a designated initiative committee and a filing fee. The application and bill then go to the Department of Law to verify statutory compliance and constitutional compliance with the initiative restrictions I just talked about. Once certified for the ballot, that's the main hurdle, or the first big hurdle anyway. The Division of Elections is required by statute to print petition booklets for statewide circulation. The sponsors have to collect, they have 1 year to collect a certain number of signatures distributed throughout the House districts in the state based on the turnout of the prior general election. The petition booklets contain both a summary of the legislation, which is sometimes worked on collaboratively with sponsors and the Lieutenant Governor's office, and Department of Law, as well as a cost statement, which is an estimate from the Office of Management and Budget as to what it will cost to implement the law, not just from the election side, but from the actual substance of the law itself. It's the equivalent of a fiscal note. And it's quite an undertaking to do all of this, obviously. Again, and then finally, after all the signatures are gathered, usually with a significant buffer, petitioners will file their booklets with the division, and the Division of Elections will verify all of those signatures. Sponsors then have to wait out one legislative session to see whether the legislature passes substantially similar legislation. The legislature is required to hold hearings on initiative bills. They often don't do that. I guess they can ignore their own statutes. I don't know. But if they fail to pass substantially similar legislation, the initiative goes on either the primary or the general election ballot based on the date of legislative adjournment. In recent years, it's been mostly the general election given late adjournments. I have not seen a ballot initiative on the primary ballot in my tenure working on these issues. So we see this year 2 ballot measures, both of which were litigated at the certification stage. The ballot measure the oil tax initiative and the Better Elections initiative, both of which the Attorney General's office rejected on certification, both of which were overturned in the Alaska Supreme Court and placed on the ballot. Then the question goes to the ballot in a yes or no format. The question is posed, yes, should this become law or no? If rejected, obviously the law fails. If enacted, the law becomes effective within 90 days of certifying the election. And again, the legislature can amend that bill, that initiative bill at any time, but not repeal it within 2 years. So that is the, the lengthy overview of the ballot initiative process and the contents of my article. And I'm hoping my article will serve as sort of a manual on how to get initiatives on the ballot in a way, and the pitfalls to look out for, and the standards that the Supreme Court will apply both before and after the election on these issues. So that's my opening spiel on that. And I guess I'll punt to the next person on the panel, to Professor Flanders or Professor Metzloff. So.
Yeah, well, thank you. I think that's really fascinating. I think there will be some questions, and I should have mentioned this in my opening. We will have a question and answer period. So if anyone wants to put questions on chat, we will monitor that and get to try to ask as many. I certainly have lots of interesting questions on your perspective on how has this served to be an important part of Alaskan democracy. There's lots of challenges about how to get them on. I mean, each one of these things, like the one issue rule, could be applied in a way to make this process less effective or less real. And I certainly will want to know a little bit about your views as to sort of how it stands. And do you expect that the initiative procedures will be utilized sort of increasingly in Alaska for important issues going forward? So but it's a terrific setup for understanding its practice and history. But I think we will come back for maybe some assessments of your view of the utility of this process in contemporary worlds. So Professor Flanders, Chad, help us understand a little bit about your take on a really interesting recent issue that came up to the Supreme Court, not for a full opinion, but raised some questions about what you call Alaska exceptionalism.
Sure, thanks. And yeah, I just want to second the comments in the chat about Libby's article, which is both brilliant and useful. I have to share with you a little bit of my panic during the break we had, because of course that was a great talk by Dean Chemerinsky. I think he talked authoritatively and in a very short period of time about a lot of things we'll be covering today, and actually a lot of things I was going to talk about too. So I was sort of worried what I was going to do, and I was concerned about coming off as sort of a poor man's Dean Chemerinsky. But then I reflected a little bit, and being a younger professor, one could do worse than aspire to be a poor man's Erwin Chemerinsky. So I decided to go ahead with what I'd planned to talk about. The comparative advantage or the benefit I may add is, so I'm in Missouri now, and I've been working with the Missouri Commission on Civil Rights, where we've been looking at Missouri's sort of election preparedness given the pandemic, given the difficulties and the concerns people have with going out to vote. So I may share some of the work we've been doing in Missouri, but I will talk a lot about Alaska election law too, and hopefully not be too redundant on Dean Chemerinsky's talk. I have to say, it's always worth it. I'm trying to think how many times I've seen him speak, at least 4 or 5. At least one time I flew from Missouri just to see him talk. I flew 8 hours, saw his talk in the morning, and then flew back. I feel like I should have a Chemerinsky punch card and get like a free drink at Kaladi Brothers if I go to enough talks. But I'm also honored just to be on this panel too, with a fantastic paper by Libby. And I will say, when I clerked on the Alaska Supreme Court, if there was a case where Orlansky Feldman was involved, you knew you were going to get good briefs, you would stop everything to watch the oral argument. So it's really, I'm both humbled and it's a real honor. So I'm going to talk about 2 things and relate them to Alaska and relate them to some national trends in election law. And if you'll indulge me a little bit, I'm actually going to go back in time to an article I wrote 10 years ago for the Alaska Law Review, and I was able to find a copy in my office. And this was back when there was a huge controversy. So this is when Lisa Murkowski lost the Republican primary to then populist insurgent candidate Joe Miller, and then opted to run as a write-in candidate. And for those of you who recall that, there were a lot of interesting issues raised with her write-in candidacy. And the one I focused on in my article was about the spelling of her name. And so there were concerns about if people wrote in her name and misspelled it, would it be counted? And there are all sorts of interesting side issues about when was it a genuine misspelling and when was it meant to be sort of a parody vote? There were, like, if someone wrote in Lisa Muskowski, I think that was one example, would that count as a vote for her, or was that meant to reject her candidacy? And there was also a related issue about to what extent could poll workers assist the voter? If a poll worker had a question about the correct spelling of Lisa Murkowski's name, could they go to the poll worker and say, hey, can you help me write this vote in? Could poll workers provide a list of the correct spellings of the names of various candidates who voters might want to write in? And I focused on the issue because I thought it raised a broader question about assistance to the voter in a given election. And the question was something like, how much help can a state give to voters in making sure that they do vote, and that their vote counts. So, because there was a point at which if Lisa Murkowski's name was spelled badly enough, they would just throw out the vote, not count it. So the question is like, what steps can the state take to make sure that doesn't happen, to make sure the intent of the voter gets realized in the actual ballot and the ballot is counted? I see a similar question being raised much more dramatically during this election season, and it's being asked by states all over because there's a pandemic and people don't want to go to the polls, understandably. And in my role as on the commission, Missouri Commission for Civil Rights, we've talked to a lot of election officials in Missouri, and this is true nationwide. Hard time recruiting poll workers, hard time finding places to have polls. Like nursing homes used to be a great place where people could go vote. Now they're like, no, thank you. We'd rather not have a ton of people coming into our nursing home and risk spreading COVID-19. Churches are also reluctant. So there's concerns about in-person voting and so alternatives to in-person voting. And so the question in the way it was sort of raised in a way with the Lisa Murkowski case, how much assistance does the state have to give to the voter when it means expanding the range of options to be able to vote, to not only be able to vote in person on election day, but also to be vote early, to vote by mail, to vote absentee? How much assistance is the state really obliged to give? And a lot of states have responded, including Missouri, by passing new laws to make absentee voting easier, to allow for mail-in balloting options. Some of this is in giving expansive interpretations to older laws, generous readings of what it means to vote absentee. And some state officials have made allowances to this extent. New Hampshire, for example, has said, look, if you're afraid of getting COVID-19, that means you're restricted from voting for reasons due to illness. Missouri has a similar provision. Our Supreme Court recently said, no, that you're only restricted due to illness if you actually are sick. So there's a lot of practical questions here, but I think they raise indirectly this foundational question of what does it mean to actually have the right to vote? It's sort of this foundational, even philosophical question, because it becomes harder to say in a pandemic that you have the right to vote if you are able to vote in person on election day, because people understandably may not want to take that risk. When we were working on the commission, our governor, Michael Parsons, came out and said the following: I hope people feel safe to go out and vote, but if they don't, you know, the number one thing, their safety should be number one. If they don't feel safe, then don't go out to vote. Those are like interesting sentiment, but a little disturbing because it suggests a choice voters may have to make, and Professor Chemerinsky raised this question, between their safety and their ability to go out to vote. What worries me in a lot of the cases that have come out, both the Missouri Supreme Court opinion, various federal appellate courts opinions, is the way they refer to absentee balloting and mail balloting. They refer to it as a privilege or as a luxury. And the idea is that states don't have to provide other alternatives. They don't have to provide all alternatives to voting in person on election day. Even when it's admitted that voting is risky, even when there may be advice to sort of like limit in-person interaction as much as possible, courts have been, by and large, fine to narrowly read provisions for absentee balloting and mail-in balloting, precisely because the core of the right to vote, these courts say, is the right to vote in person on election day, even when this may present a risk. What I hope to see, or what I think we will see, is a fundamental shift in our understanding of what the right to vote entails and what it means to have access to the ballot, from this idea that the right to vote just means being able to vote in person on election day, to something more like the ability to have access to the ballot, so that, as in Missouri, we're wrestling with, because sometimes when you want to vote mail-in, you have to get it notarized, which is an additional hurdle you have to overcome in order to get your ballot. The mail has to arrive on time. And so my hope is, or what I'm looking for is an expansion of the idea of what it means to have the right to vote guaranteed in your particular instance, where this may go beyond just, well, you can always go in person and vote on election day. So that's sort of like some of my reflections on something I wrote 10 years ago and how it may have new relevance today in thinking about the nature of the right to vote. But now I want to say a little bit more about what Tom indicated as my paper for this year's symposium, which is about what I call Alaska law, exceptionalism in campaign finance. And it discusses a bunch of recent Alaska campaign finance reforms, especially limits on the amount individuals can contribute to political campaigns, to politicians. And Alaska set that, first by the legislature, then by initiative, to a fairly low amount, $500. And so this was the subject of a case that went to federal court, decision by the Ninth Circuit, went up to the Supreme Court. Supreme Court made a per curiam decision, sent it back down for a remand, and that's where it stands now. And the theme my paper explores is, again, I call it Alaska exceptionalism, but listening to Dean Chemerinsky's talk today, it's really an issue of federalism. And it's what I see as a tension between the Supreme Court's fairly aggressive reading of the First Amendment regarding restrictions on campaign spending, and each individual state's ability to experiment with different kinds of limits on campaign spending, given their unique characteristics as a state. And so in Alaska, the dynamic is fairly clear. There's one industry, the oil and gas industry, which dominates the economy in Alaska, and understandably, given its self-interest, wants to influence politics and create a political regime that's favorable to its economic interests. You have that, sort of the dominance of one industry as opposed to many different industries who might be competing for the ear of various politicians. So you have an industry that dominates the state of Alaska, and then you have a relatively small legislature. So it's a lot easier to sort of capture that legislature. You don't need to influence that many people. So you have like a smaller legislature plus a major industry player, perhaps that sort of like crowds the field in terms of economic interests in states. So you might want to limit the ability of that industry to influence the Alaska legislature. And so the campaign finance reforms that Alaska has passed in the past decades reflects that concern. And it's been a concern since the beginning of Alaska, that the natural resources of Alaska might lead business interests who want to sort of influence politicians to create an environment favorable to their economic interests. So this case is called Thompson versus Hebden, and I want to sort of put it in a context of both the Supreme Court's campaign finance jurisdiction and also its concern about federalism. So it's what Thompson versus Hebden does is put another plot on the sort of line. There was an earlier case, campaign finance case coming out of Arizona. Arizona had a novel campaign finance regime, and they said, no, actually, that puts too many restrictions on the First Amendment rights of people able to run for campaigns, to give to campaigns, and they struck it down. So you see sort of this uniform idea of campaign finance regulation based on this strong idea that money, giving money to campaigns, spending money on behalf of campaigns is First Amendment protected speech, and that sort of cuts down options for restrictions on those that states might want to innovate based again on their unique characteristics. And it results in sort of a one-size-fits-all idea of campaign finance. So I think this is unfortunate for a number of reasons. I think it shows a trend of the court finding fewer and fewer interests that are preserved by regulating campaign spending, because Alaska, in the course of litigation, asserted a bunch of different interests, ideas of self-governance, ideas of preventing the appearance corruption. It's looking like the Supreme Court is really focused on this idea of quid pro quo corruption as the main thing that campaign finance should be geared towards restricting. And you certainly can't, certainly post Citizens United can't just say, we're worried about sort of a lot of money flowing through the system and how that sort of looks bad. It's got to be really kind of tethered to this fear of direct corruption of the legislature. And it also shows, I think, also a trend of the court in treating direct contributions to politicians, namely they're called contributions, and spending on behalf of politicians, expenditures is the name given to it under the Buckley case. Treating those as the same, it had been the case that contributions could be regulated more heavily because contributions, I'm just giving money directly to a politician. That can look like I'm trying to bribe the politician, as opposed to when I'm spending money on behalf of a campaign, then it's sort of my own speech. The candidate may not even like what I'm saying, but if I give money directly to a politician, there may be a greater corruption risk. I think the court is looking at contributions and expenditures more and more the same. Certainly some of the justices think they should be treated exactly the same. Strict scrutiny should apply to both of them. So there's a federalism concern when it comes to campaign finance. Can states experiment with different ways of regulating campaign finance based on their unique characteristics of states? But this goes to something that Dean Chemerinsky was talking about, which is the concern about the Supreme Court's role in regulating states and what they do about campaign finance. And we've been seeing this in the past couple of weeks in the litigation running up to Election Day in a few days, because the Supreme Court has more or less suggested a willingness to intervene and to intervene on the interpretation of state law matters. Some of this may be justified. Some of it I think is worrisome. Dean Chemerinsky mentioned the recent Wisconsin case where Justice Kavanaugh cited Bush v. Gore and the right of the federal courts to intervene and uphold the power of state legislatures as against state courts, state statutes as against sort of interpretations of the state constitution. There was an Eighth Circuit court, that's sort of the court, the circuit that Missouri is in. It came out of Minnesota, and it sort of hits at both of my worries. So it was sort of good timing for my talk, because the Minnesota Secretary of State extended the deadline for mail-in balloting, said, look, if it comes in a week after the election, that's okay. The statutory rule was it's got to arrive by a certain time on election day. He said, we'll wait a week. We're concerned about the US Postal Service coming in. We're concerned about whether people got their ballots on time. So there was an agreement. Secretary of State said, all right, we're all going to count ballots until a week after the election. The Eighth Circuit Court reversed this and said, nope, you've got to stick to the legislative rule that says ballots have to be in by election day, even though the Secretary of State was interpreting that rule pursuant to a delegation of power that the legislature had granted to the secretary. So it showed a willingness of the Eighth Circuit, at least the federal court, to come in and intervene in interpretation of state law matters. And that's a federalism concern too. And it goes back to Bush v. Gore, where the Supreme Court stepped in and said, hey, actually, we're going to uphold the power of the state legislature against your interpretation of it, state courts. There's a lot of complicated issues here, and I don't presume to know them all, but I do see sort of a concern on the part of many people that the federal government will come in and sort of restrict the ability of states to innovate in the sphere of campaign finance, but also to sort of stop a lot of more sort of immediate reforms that go to ensuring the right to vote during a pandemic. That's all I've got, and I look forward to the conversation. Thanks.
Thank you. I know one question I'd like to come back during the question and answer period is really for you to help us think about, is there any chance that as you read Citizens United and these other cases, that the $500 limit on contributions, how does Alaska try to justify that? Is there some way that they can prove that there really is something special about Alaska and prior elections? Because Justice Ginsburg in her statement did provide some sort of a clue saying, Alaska is different, it's a small state. There really is this industry that has a unique sort of dominance in terms of the economy and whether there's something there to work on. And I think what we're seeing in the comments, as you related back to Dean Chemerinsky's talk, is, these election issues of democracy proceed on several fronts. It is who gets to vote, and you're right to say, how easy should we be able to make it, or how much can states get in the way to make it hard to vote? It has to do with contributions. It has to do with concerns with redistricting, and maybe Alaska doesn't have quite the same redistricting concerns that Wisconsin or North Carolina has, but the complexity of what we think about as democracy working is very real. And so that plays off against the initiatives, which is, a very different way of legislating in some ways, legislating by the people more directly, as we heard from Libby. So I'd like to turn now for Susan Orlansky as a commentator. What that means is she's not writing a paper that's being published, but given her vantage point from thinking about so many issues and working with litigants challenging election issues in the Supreme Court, to kind of present some of your views, Susan, as to things that you're thinking about and the future issues that may come up in this context.
All right, well, I'm going to start by thanking Libby and Chad for their informative discussion of several aspects of ballot access. And my plan is, rather than take a broad view, is to focus much more specifically and talk briefly about ballot access issues from the perspective of the right to vote to recall an elected official. And that's one of the pieces of litigation that I've been involved in most recently. As both Dean Chemerinsky and Libby have noted, the Alaska Supreme Court identifies recall, referendum, and initiative as related, in the sense that all are ways that voters can check the activities of elected officials over and above the right to elect someone different at the next scheduled election. The right of recall is a lot like the right of initiative in that both are guaranteed in the Alaska Constitution, but it is statutes drafted by the legislature that define the procedures and grounds. What's different is that unlike with initiatives, there is so far very little Alaska Supreme Court case law applying and interpreting the relevant constitutional provision and statutes. Currently, there are just 2 Alaska Supreme Court cases, and they both deal with attempts to recall local school board members. Recall of officials outside of state government is regulated by separate statutes from those that are applicable to elected state officials. They're very similar, but they are in 2 different parts of the Alaska statutes. One of these days, maybe very soon, there will be an Alaska Supreme Court decision addressing the statutes on recall of state officials, and that will be the decision in State versus Recall Dunleavy, which will explain the court's holding that the application for a petition to recall Governor Dunleavy is legally sufficient and can proceed. The court issued an order in May, a couple of months after the oral argument, stating its holding and that an opinion would follow. While we wait for that decision, it seemed to me a good time to think about the questions the Supreme Court may address and how they could relate to the questions of ballot access. My nightmare was that the decision would come out this morning and I wouldn't be able to talk about what might happen and would be forced to talk really quickly about what did happen, but there's no decision this morning. Full disclosure, I represent Recall Dunleavy, and it is entirely possible that my advocacy shapes my thinking, but I have tried really hard here to frame my comments as neutrally as possible. In very broad terms, I think that there are 3 questions related to ballot access that the Supreme Court may address in the Recall Dunleavy opinion. The first is to explain how much the 2 prior decisions on municipal recall efforts will apply to state recall. And I think it's fair to say that both sides expect the Supreme Court will rely on those decisions and find them applicable. If the Supreme Court does, that will mean that the Supreme Court embraces 2 main points from those earlier cases. One, that recall is fundamentally a part of the political process and statutes therefore must be construed liberally so that people are permitted to vote. The second is that elected officials in Alaska cannot be recalled for legally exercising the discretion that's granted to them. In other words, Alaska officials cannot be recalled just because voters dislike some of their policy decisions. Recall in this state needs to be based on cause, which means the asserted facts need to establish one of the grounds listed in the applicable municipal or state recall statute. With respect to the broad question of ballot access, those 2 principles from prior cases are obviously in some tension. The first principle favors broad access to the right to vote to recall an official, and the second restricts access to the ballot. My personal prediction is that the Supreme Court will reaffirm both propositions as applicable to efforts to recall a state official, and we will continue to have to live in that middle ground. The second set of questions the Supreme Court may address concerns the requirement that an application for recall must include, and this is a quote, the grounds for recall described in particular in not more than 200 words, end quote. That word limit and how it bears on the sufficiency of the statement of grounds was not at issue in either of the 2 prior cases. So the Supreme Court will write on basically a clean slate in terms of its own precedent if it sets out to provide answers to the question, how much detail is needed to satisfy the requirement to describe the grounds for recall in particular. And it may not be too hard if you've got 1 ground, but Recall Dunleavy went to the voters initially with 5 grounds, and that doesn't leave many words for describing any one of the grounds. In the litigation, Recall Dunleavy argued for essentially a notice pleading standard. In other words, it should be enough if the application provides the targeted official with sufficient information that the official understands what he or she is alleged to have done that is a ground for recall so that the targeted official can prepare a defense. The state argued for a much more demanding standard, pointing out, accurately enough, that the first review of sufficiency is by the Division of Elections, which may not know as much as the official about the issues relied on by the would-be recallers. In this particular instance, the governor's conduct that's at issue in the recall application was relatively high profile. So it was largely hypothetical for the state to contend that the recall application wasn't factually particular enough to apprise the governor or the Division of Elections of the 4 specific acts alleged to be grounds for recall. But there could be other cases we could imagine in the future where it would be less reasonable to expect the Division of Elections personnel to know exactly what the issue is if only a few words are offered in a petition to recall, let's say, a state representative. Because the Supreme Court allowed the recall Dunleavy effort to proceed, the court obviously concluded that the application here met the factual particularity requirement. But it will be interesting to see if and how the Supreme Court defines what is particular enough as a guide for future cases. With a 200-word limit on a recall application, requiring too much particularity obviously would hinder ballot access in future recall situations. So the third set of questions that the Supreme Court might decide to discuss would be how to interpret or explain the 3 statutory grounds for recall that the recall Dunleavy application relies on. And those are 3 out of the 4 in the state recall statute: incompetence, lack of fitness, and neglect of duty. As you can see, they're all really broad and they're not defined in statute. Recall Dunleavy alleged that all 3 were satisfied with respect to each of the 4 acts alleged as a basis for recall. The Supreme Court conceivably could decide to address just one of the grounds and conclude that having one legally sufficient ground is enough, or it might address all of them. The state attempted to give each of the statutory grounds a really narrow meaning, saying that this is necessary to ensure that recall really is for cause and not based just on disagreement over policy decisions. For the same reason, the state tried to incorporate a materiality standard, a requirement that the application show that the official's conduct caused some harm. In the state's view, no official is perfect, so it's easy to find something that fits in a very broad definition of neglect of duty or lack of fitness. So it's too easy to launch a recall effort on a nominally adequate ground and then gather signatures, not because people care about that ground, but because they dislike the official's policy decisions. There's always some risk of that, no matter what the ground is. No one is asking voters signing a petition what is the real reason they are signing. Recall Dunleavy resisted the narrow definitions that the state proposed and relied heavily on a couple of Superior Court decisions that used broad definitions and that did not require harm. Again, because the Supreme Court ruled that the recall application is legally sufficient, we know it found that the allegations satisfy one or more of the grounds, but again, it will be interesting to see what the Supreme Court says that elaborates or explains the grounds. In its very first case on recall, the Supreme Court acknowledged that the grounds, this was the municipal statute, but they're real similar, acknowledged that the grounds are broad and not defined in the statute. And it said then that providing further definition is largely the legislature's job. So part of me suspects that the Supreme Court will not want to provide a lot of definition or detailed guidance this time either. On the other hand, Justice Stowers dissented from the holding as to 2 of the 4 bases for recall, and that could be a reason for expecting a fuller decision where each side explains its views. Relevant to today's broad theme on ballot access, it's obvious that a Supreme Court decision that keeps the definition of the grounds for recall broad will facilitate broad ballot access on recall questions in the future. So I'll end by saying simply, we're all going to be waiting to see what the Supreme Court actually says.
Well, thank you. Fantastic, Susan. I really appreciate it. I think when we combine the 3 comments that we've heard today, is I think we realize the complexity of what we mean by sort of democracy and elections in the state of Alaska, where we have, it's not just voting for a particular person. It's not getting a legislature and sitting back. It's much more active. It is a combination of this initiative process, It is the regulation of who votes and how we vote, and campaign finance report issues that Chad brought up. And so we do have a question. Chad, go ahead. I see you have a question for Libby, and as I always do like to have the opportunity for the panelists to share, because we're seeing the, there's no simple answer here. We're trying to relate an initiative process with campaign regulation with a recall provision that is not as well formulated yet, but perhaps maybe Monday, maybe if it wasn't today, Susan. So go ahead, Chad.
Yeah, I've actually got a question for both Libby and Susan, because there's a case when I was clicking on the Alaska Supreme Court that talked about certain presumptions when looking at election laws in the state of Alaska. And the presumption was always like, if it's a close call or if there's an ambiguous statute, always read in a way that provides for greater access to the voter. So I think the question at issue in our case was like, was this particular candidate term limited out, or did he have more years to serve? The court said, well, we're going to read this in a way that allows the voter to choose. So this guy can go on the ballot. He's not prohibited from being on the ballot. I'm wondering if there's any statutory or presumptions as to how to read the statutes when it comes to initiatives. Like, well, if it's a close call about whether there's a single subject or not, or on the side of finding a single subject. So too with recalls, although Susan, it strikes me as a much more interesting issue, like, because democracy might be on both sides. Like, we don't want to make recall too easy because after all, the people did elect the governor, but we don't want to make it too difficult because the people should have the ability to recall a governor they think has gone wrong in any number of ways. So I'm just wondering if there's any presumptions that sit on either side when the Alaska Supreme Court considers these types of cases.
Well, I'll start. There's one easy answer in the recall situation, and that is there is a statute. I'm grateful I was able to find it quickly here on my desk, but there's a statute in Title 15 on the basis for denial of certification of a recall application. And it says that the director shall deny certification upon determining that the application is not substantially in the required form. And the Supreme Court read that kind of language in the earlier cases as a standard of substantial compliance. So there's at least a statutory basis. The Supreme Court talked about liberally construing the statutes in favor of the right to vote in the two previous recall cases. And we certainly relied on that heavily in our briefing. So it's primarily the case precedent we rely on, but here, at least, we do have the sort of language of substantiality in the statute, which I think gives us some basis for rejecting, for the courts or the Division of Elections, rejecting something on a hyper-technical ground.
Very helpful. Libby, did you have any response?
Yeah, so the statute that Susan just mentioned, there's an analog in the initiative statute as well that talks about substantial compliance, having the initiative bill being in substantially the required form, and going back many decades, opinions of the Attorney General's office conclude that substantially in the required form means compliance with those constitutional restrictions ahead of certification. But I think the presumptions that Professor Flanders just asked about are mostly embodied in case law, and the two principal presumptions that come out of the case law on ballot access is broad ballot access and voter intent. The Supreme Court, our Supreme Court, really prioritizes those two principles. So whenever there's any ambiguities, they are typically resolved in favor of ballot access and voter intent. So the idea is that we start with a presumption of those of honoring voter intent and opening the franchise, maximizing access to the franchise and to the ballot. And it really is a burden shift to a litigant trying to keep something off the ballot or trying to argue against whatever apparent voter intent is to make those showings, because those are very well-established common law principles in the state.
Can I follow up on a question, Libby? Because I was thinking about Chad's concerns with campaign finance, and we see in Alaska efforts to control campaign finance. That makes a lot of sense to think about contribution limits when you have specific political candidates. It's much harder to think about that if a significant amount of decision-making is being made through an initiative. how do you see that as a problem in Alaska in terms of who's spending how much money on these initiative measures? Is there been concern? Has there been thinking about how do we control and regulate sort of who's spending money on these initiative matters? We know how to limit it for a candidate. How do we begin to think about it in this context?
Well, I think that's going to require, a statutory change probably. Certainly the state is not allowed to expend state funds on opposing or promoting a ballot measure, but it's sort of, to me, it's sort of a what's good for the goose is good for the gander situation. You start from the premise of Citizens United. You have United States Supreme Court has declared corporations to be people and people to have essentially unlimited free speech rights. And so, we see this sort of playing out with ballot measure 2, where you've got, quite a significant funding effort on one side to pass the measure, a slightly less significant funding effort, I think, on the other side to oppose it. But again, and on the oil tax initiative, you see a huge amount of money going into defeating that measure from the oil industry, which has endless money to spend. I do think it can have a significant impact on the democratic process, but that ship has sailed. And I don't think that ship is coming back into shore without a federal constitutional amendment. That said, ballot measure 2, if passed, would create a little bit more transparency. Not, I believe, and Scott is more of the expert on this part of the measure, but not in the ballot measure context as much as the independent expenditure groups and other candidate expenditures. But I do think it has kind of a not great impact on democracy, but this was what our Supreme Court, the lot that was cast in Citizens United.
Are there any disclosure? I mean, Dean Chemerinsky talked about, hey, disclosure requirements are a way you can go. Even in Citizens United, they were approved, although Congress hasn't passed any significant disclosure requirements for contributions. Do you know in Alaska who's spending how much on initiative matters?
I think it's a little bit harder to find out. I mean, I think it's sort of open secrets. You can find the stuff out if you look for it, but it's not particularly available to the average citizen to just easily find that information out. I don't know, maybe Professor Flanders knows more. We're starting to wade into like the campaign finance arena, which is a little bit out of my wheelhouse.
Yeah, I was just wondering if people are talking about that issue because these are some high profile initiatives. And, I don't know, as your prediction is there's going to be continued to be high profile initiatives in Alaska. Maybe it comes and goes. It depends on what's going on, but
I think as long as the legislature isn't doing what people want to see, then we're going to continue to see initiatives. I mean, legalized marijuana is a great example of that. Minimum wage being raised was an example of that. I mean, these are actually fairly progressive policies. Permanent fund voter registration access was another one. And what's interesting about the way things break down on political lines is even though the candidate elections tend to be fairly conservative, initiative measures that tend to be fairly progressive do pass in the state. So I have a prediction. I have a very strong prediction about the outcome of this entire election that I won't really share until after the election is done. But I'll be interested to see if I'm right about this because I have a feeling about all of it.
I think what you're saying about the campaign finance reform, I do want to come back to Chad for a minute and kind of speak about, really focus on this exceptionalism issue for Alaska, because what Alaska did seem, $500 per person is a lot less than the current federal campaign limits. But, Alaska is a small state in terms of number of voters, not that many legislatures. Do you think there is any chance, as you read these cases, that this will be upheld? Justice Ginsburg again tried to signal that perhaps there's a way. The majority opinion and the order from the Supreme Court seemed to, I think, sort of say this probably isn't okay, but we're sending it back to the Ninth Circuit. Help us play a little Nostradamus for us and predict what you think is possible.
I want to hear Libby's prediction. I think
Yeah, I do too. I will have to, but she doesn't want to. I think she doesn't want to tempt fate,
Right.
So she's.
I'm terrible at predictions, but I think the answer is no. I think I think what Ginsburg said was helpful because she's just sort of said, look, Alaska is unique, and the low amount of money goes to the industry dominance. It goes to the size of the legislature. It doesn't cost a ton of money. I mean, this is all stuff that was gone over at the district court level. It's like you don't have to spend a ton of money to advertise, to go places. It's not as expensive to run campaigns. But my sense is just that the trajectory of the court is so skeptical of restrictions on money in campaigns, because I mean, and it may be, you can be cynical about it, but I think it's rooted at least in part in a belief that spending money is a way of speaking in sort of a modern democracy. And just to pick up on something Libby said, the initiative referendums, that was sort of the gateway to treating corporations as having robust First Amendment rights. And in a case called First National Bank of Bilotti, I think it was, sort of like corporations were giving tons of money to pass this ballot measure. And the court said, hey, look, they have things to say. They have an interest in this, the outcome of this referendum. And it was such a critical case because it didn't involve a person. And so the court was like, we're not so much worried about corrupting a ballot measure. But what's really interesting about ballot measure 1, ballot measure 2 is because they worry me in sort of different ways, because like ballot measure 1, you see the influence of oil and gas money against the oil tax. I mean, I was in Fairbanks over the summer. It's just impossible to watch 5 minutes of TV without seeing an ad saying, you know, it's going to hurt business. We shouldn't raise taxes given the effect of the pandemic on the economy. Ballot measure 2 is also, and I think Angela's paper helpfully laid this out, that there's real outside interests who are sort of behind ballot measure 2, and with the idea that, well, we can experiment with Alaska. And sort of like, I'm torn about the good of initiatives. Dean Chemerinsky mentioned one concern is like, well, there's a legislative process and there's some good things about going through the legislative process. You might say on the other hand, like, look, it's good to have direct democracy in the way the initiative process preserves, but if it's being pushed by outside interest, then it's sort of like, to what extent are we sure that this is a real democratic movement, as opposed to just an opportunity for other outside interests to come in and try and have their way. So that's what concerns me. And that was one of the interests that opponents of the campaign finance reforms, like, we have an interest in self-governance. And that was the thing that even the Ninth Circuit struck down, which is to eliminate or to put a limit on campaign contributions from outside Alaska coming in. That was struck down because there's like, well, there's no real interest in self-governance, and you haven't really shown a corruption interest that's strong enough to limit campaign contributions in that way.
And that's actually a very interesting topic. You know, there's so many Senate races going on now. One of my students is from South Carolina, and Lindsey Graham is really bemoaning the amount of money that's coming in from outside the state for his opponent, much of which seems to be coming from my wife. I think I keep telling her, okay, enough. We got our own election, you can do that. But really fascinating to think about whether the tremendous amount of money that's moving within the United States will give rise to some new potential campaign limitations based on statehood, which I'm sure that's been thought of before, but I think we're going to see some of that. Our time is up. If there is any, Bertie, I haven't seen any questions in the chat. Cormac, have I missed some, or we're good? Okay, so I really want to thank our panel. I mean, very different parts of the world that we're thinking about elections, and I was just struck about, you know, they're all part of what we think of as democracy, and it's complicated issues, and Alaska is in the middle of thinking about it. And we're going to come back after our break and really focus on Alaska ballot measure 2. Very excited for the discussion that we'll have on that. So tell me the time, Cormac, that you want to. Should we start back at 11? That's about a 12-minute break. Or you?
We can give people a couple more minutes. Do you want to do 11:05 Alaska time? So just over 15 minutes.
Ryan, you're in charge. You're our Alaskan.
Yeah, I think that's good, because I know that the ballot measure 2 is open to the public via live streaming, and so we may have some people joining late. So I think starting at 11:05 would be good.
Okay, so people can stay on Zoom here. It is going to be available on what's the other medium?
There is a YouTube link for non-attorneys to watch separate from the conference that's being live streamed.
But if you're here on Zoom, it's going to continue to be on here. It's also going to be on a YouTube channel because we have some non-lawyers coming in to watch. So we'll
Maybe you can post the YouTube link on the chat, so if people want to distribute it to others, then they can do that.
Okay, so we will be back and starting promptly at 11:05 Alaska time, right?
Yep.
Thank you.
Okay.
Thank you again to the panel members. Thank you, Chad. Thank you,
Yes, thank
Libby.
you.
Thank you, Susan. Really terrific.